Welcome to Questions That Matter, where we discuss the important and interesting work done at TrustBridge. Today we have with us Prashant Narang, who's going to tell us a little bit about what's going on in the world of public procurement and disputes. So Prashant, there was a recent Supreme Court ruling, I think it was called the core ruling or the core judgment. Can you tell us a little bit more about it? What was it about? What were the issues that it was dealing with?
Thanks, Renuka. Yes, Cole versus JV ruling given by the Supreme Court was a game changer. Earlier, the public contracts could have clauses that allowed PSUs and government departments to unilaterally appoint arbitrators. This practice essentially stacked the deck in favor of the government because they could have their own appointments. So even if they were not directly related, these arbitrators were not directly related to the company, meaning that they were not employees or even former employees of the company, the other party would always apprehend that such appointments may be biased and the arbitration proceedings may be tilted in favor of the PSU. So what the court did, it found this practice repugnant or in violation of the fundamental principle of equality and impartiality. And Justice Chandrachud also mentioned in his judgment that this would be in violation or against the ethos of the impartiality and fairness that arbitration law is supposed to promise. So this practice is done away with. So which means that no longer can a PSU unilaterally appoint arbitrators, and so it has to have say from the other party as well. And I hope that this would boost investors' confidence and also the confidence of private contractors, concessionaires, whoever transacts with the government.
That's interesting because on the other hand, we also know that the finance ministry last year came out with a memo that had some choices on, when to go to arbitration and when not to go to arbitration. So can you tell us a little bit about what's happening on that front?
Yes. So cumulatively, it makes an interesting departure from the policy regime because, what we just discussed, that the judgment makes it difficult for the government to have unilateral appointment of arbitrators. And this office memo issued by Ministry of Finance, prescribes again to move away from ad hoc arbitration. So for smaller disputes, there would be institutional arbitration, but for larger disputes, it prescribes going back to litigation. So it adopts a tiered approach. This tiered approach is based on the quantum of claims. So small disputes, as I said, go to institutional arbitration, which is really good because institutional arbitration promises way more unbiased, impartial, fair dispute resolution as opposed to ad hoc arbitration. And this is something which the government acknowledges in the office memo. Also, ad hoc arbitration had become very expensive because the arbitrators, especially the retired judges, would charge on per appearance or per sitting basis, and there would be other expenses as well. Institutional arbitration is not as cheaper, but at least the fee is ad valorem. It's a lump sum fee that is paid and it goes to the institution. So in that sense, it's perceived to be fair as compared to ad hoc. But the question is that going back to litigation, even if it is followed or first they try out mediation and then they go to litigation, that is being questioned by a lot of lawyers because we know that litigation is painfully slow. So why go back to litigation? And that will have adverse consequences for private companies, investors, concessionaires and contractors, whoever transacts with the government.
Sure. So, it looks like there's a lot of movement on trying to get arbitration to be more efficient in India than it has been. And so according to you, since you've been studying this space for a while now, according to you, what else can be done to make India an arbitration-friendly destination, if you will. And with that, what I mean is that there is fair play in how arbitration is done, and therefore, it leads to A, India being the seat for a lot of arbitrations, and B, for the contracts in India to have more validity and to have more certainty. And so, what do you think are the changes that we need to make to get to that place?
So as per the office memo, uh, government and the PSUs, government departments and PSUs are going to adopt institutional arbitration for small claims. I suggest that they should expand the ambit of institutional arbitration to all disputes and not just limit it to small claims, because it's not a good idea to go back to litigation for larger disputes. It might take years and then there are appeals, and so it takes almost more than a decade to get a dispute resolved through litigation. On the other hand, arbitration is way more speedier and it helps in faster resolution of disputes. So definitely institutional arbitration is the way to go. What we see now is it seems like a test phase for the government, that it wants to try out institutional arbitration for a while and then see how it goes. So we do see some hesitation in the government with institutional arbitration, but I'm sure that in the long term that they feel more confident about it and they would probably expand the ambit to all the disputes. That's one thing. Second thing is that there's a need for comprehensive data monitoring. So we need to monitor all PSU related disputes, so whatever forum we are trying or whatever, wherever the disputes are, so be it litigation, and we know that many of the arbitral awards are challenged in the courts. So those disputes, the arbitration related proceedings, and if they are trying out mediation, there has to be a comprehensive data monitoring of all the disputes to be able to then make a judgment in future, what is working and what is not working. Currently, the issue is that a lot of this data is not available in public domain. So we don't know if the government is already collecting this data, but transparency is the key for better decision making. So this data has to be in public domain. The policy making has to be data driven. It has to be evidence based policy, and for that disclosure is the norm, because PSUs also don't put this data in the public domain, so it has to be available for the general public to see what is working and what is not working. Third thing is that as a result, as a consequence of the office memo dated 3rd June, PSUs would need to revise their standard contract templates. So as we know that for smaller claims, it would go to institutional arbitration. So which institution is the question? Good thing is that it doesn't go to the courts for appointment of arbitrators because it's institutional arbitration. But the question is the choice of institution. So there the government needs to actually also have some sort of criteria, some sort of judgment as to which institution to choose. So we see that the current discourse is dominated by the premier institutions, DIAC, MCIA, and so on and so forth, but there are other institutions as well. But again, we don't know how well those institutions are working. So for example, Delhi Arbitration Center, or for example, the Karnataka Arbitration Center. And Karnataka Arbitration Center actually charges way less than DIAC for the same amount. So we need to have more information about these institutions, and for the government and PSUs to opt for institution, they also need better understanding of which institution is working and how they are working. So I think with that sort of data monitoring and better information in the public domain, we can hope for a better policy making.
Well, that sounds very promising, and we hope that, given the fact that now the government is forced to go into institutional arbitration, we will see more data about how the government contracts and government disputes are faring in that space. And we at TrustBridge will be monitoring this as much as we can given the publicly available data. So please keep watching for this information on our website, and thank you for listening.
Thank you.